Hi, everybody. Today I'd like to talk with you about 3 specific strategies that you can try if your relationship with your medical malpractice defense attorney is not as productive or operating as smoothly as you had hoped it would. This will serve as the last in a series of posts on the relationship a physician defendant might have with their med mal defense attorney, and I hope you'll find it useful. For those who don't know me, I'm Dr. Stacia Dearmin. I'm a physician, and I am the owner of Thrive, where I provide insight, education, and support to the medical community at large, and to physicians in particular who are healing after unexpected adverse outcomes and in the face of medical malpractice litigation. I was blessed to have a team of 2 excellent med mal defense attorneys serve me in the course of my own litigation. And so I understand that it can be a great relationship. And when it is a great relationship, that will serve the case as a whole, just like a great physician-patient relationship serves great medical management. I hear from time to time, though, from physicians who have the experience that their relationship with their med mal defense attorney is not what they had hoped it would be. They feel like it's not as productive as it could be or not as supportive as it could be, and they're wondering what they can do about that. The first strategy that I suggest that you try in that situation is probably the simplest and most obvious, and it is to communicate directly with the attorney. In my experience, trial lawyers are much less conflict averse than we as physicians tend to be. And so I think it can be very fruitful if you're able to identify the specific areas where you feel like they're not serving you in the way that you need and go to them directly with that. If you need to, start by leaving them a voicemail saying, "I'd like to set up an appointment. Can we talk?" They typically will respond pretty quickly to that type of a voicemail because they're wondering what's going on, and you should be able to get in with them pretty quickly to express whatever it is you need to express. I'd be careful not to paint them as a failure. No one responds well to that kind of feedback, but rather try to focus on the specifics of the particular areas in which you feel like they could serve you better or in which you feel that they've failed to serve your particular needs and offer that to them. Now, I want to give you a little caveat. Med mal defense attorneys typically work very long hours, and when they're in the midst of trial, and sometimes a trial can extend 1, 2, or 3 weeks, like mine did, they tend to become very single-minded, focusing on that trial. And should your case go to trial, that's what you'll want too. All right. So if they're a little bit slow to respond to emails or to messages, sometimes some other mitigating factor, such as a trial, may be at play. The other thing you should know is that the rates of burnout in the legal community are almost as high as they are in the medical community. So try to respect your attorney as a person, have some compassion for them, offer them exactly what you need from them, and then just watch and wait. Give them some grace, hope for the best, and see what happens. All right, the second strategy I'd like to suggest to you is that you can go to the claims manager at your medical malpractice insurance company, the indemnity carrier, and speak with them about the concerns that you have. In particular, one case comes to my mind of someone I'm going to call Dr. M. That's not her real initial. She's a physician in another state, not Ohio, one of the other 49 states. And she reached out to me when she needed some moral support in the midst of her own medical malpractice litigation. Her experience was that she, as a primary care doctor, had a patient have a devastating outcome. She was really crushed because like many primary care doctors, she grows rather attached to her patients over time and tries to practice excellent medicine without overdoing it. So when this patient had a bad outcome, she was heartbroken. She was not entirely surprised, but was deeply saddened when malpractice litigation was filed against her. And then she met the lawyer who was assigned to her case, and unfortunately it sounds like it just really wasn't a good fit. She shed some tears at his office, and she was open about the fact that the case deeply, deeply distressed her. This lawyer, over time, indicated to her that he thought she needed to get her emotions under control or she would make a bad defendant at deposition or at trial, and that the malpractice carrier would not respect her as a bad defendant. Well, you can imagine this actually did not help her to get her emotions under control. It only further multiplied her distress. She did make her way through the case little by little, and eventually it resulted in a settlement. I think it's good that it didn't go to trial, and I think she felt all right about the fact that there was a settlement involved and felt good that finally she could put this behind her. Unfortunately, what no one thought to tell her is that in her particular state, when there is any type of a payout to the plaintiff, a settlement or other payout, the case automatically, by law, is reviewed by the state's medical licensing board. So while she was thinking this was all behind her, she received a communication from the medical licensing board that she was now up for review. You can imagine that was pretty distressing for her, brought up a lot of old feelings of sadness and worry, and she really didn't want to have to deal with this attorney again. Thankfully, like many medical malpractice insurance policies, her policy provided for legal support in the event that she had a review or a reason to go before her state's medical licensing board. And so she knew that she could reach out to the malpractice carrier and they would provide her with the legal representation that she required. I'm happy to say that she had the presence of mind to ask around among her physician community for names of other med mal defense attorneys who other people had had good experiences with, and she came up with the name of someone she wanted to work with. She then went to the claims manager at her malpractice carrier and told them, I don't want to work again with the attorney I worked with before. I want you to contract with this specific woman whose name was given to me. That's what the malpractice carrier did, and she had a great experience working with this new attorney on the difficult process of being reviewed by her state medical board. Her words were, this woman is amazing. The experience was like night and day. And her advice to any physician who feels that their attorney is making them feel small or worse than they already feel is that they consider going to their malpractice insurance carrier and seeking new representation. If that's what you need to do to get through the case with your psyche intact, I'd encourage you to consider that strategy. The third strategy available at your disposal is to seek a second opinion, which basically means seeking some outside counsel. Now, there is a big caveat here. I would consider this a last resort because you yourself will pay for that second opinion. You would be hiring another attorney not contracted by your insurance or your hospital to review your case and give you their opinion. The times when this might be useful are when there's a disagreement. So, for example, if the insurance company and your lawyer are pressing you towards a settlement and you feel very strongly that you did nothing wrong and you do not want to settle, you may want an outsider's opinion. A second possibility is that things are going the other way, that you yourself want to settle, but the insurance company and your lawyer are advising you to write it out. A third possibility is if some other issue that your lawyer is not contracted by the insurance company to deal with comes into play. So, for example, if you're concerned about protecting your personal assets, you might want to involve another lawyer to work on that issue for you. You could certainly hire a respected medical malpractice defense attorney in your community. That's probably what I would do. But I have also heard of physicians who hired a personal injury attorney to look at their case and give them their opinion of how they thought that it might play out or how they thought they might approach it. So these are all options that you have. In some groups of physicians that I've been a part of, I have heard some physicians say that they feel that every physician who is in the midst of medical malpractice litigation needs to hire outside counsel, because an attorney hired by an insurance company or a hospital will, by definition, be loyal to the insurance company or the hospital rather than to the physician defendant, because after all, that's where their money comes from. I myself really had a lot of trust in the two attorneys I worked with. And so when I heard this theory, I was a little taken aback. Wondered if maybe I was a fool, because it really hadn't occurred to me that that was where their heart might lie. So I spoke with a med mal defense attorney in my community, someone with a lot of experience, to get his impression on this question. And I have to tell you, his response reminded me a lot of how I feel and how I respond if a patient suggests to me that I would go so far as to make decisions about what care they needed based on what their insurance company wanted or what the hospital where I work thought would be the most cost effective. And my response in those instances is forceful, and really I don't express the anger to the patient, but I feel some anger on the inside when somebody suggests that to me, because I feel like my ethical obligation is always to my patient. My interest is in my patient. I myself don't take a whole lot of interest even in what type of insurance they have or whether or not they have insurance, other than insofar as I want to protect their interests. Well, this experienced med mal defense attorney who I spoke with about this question reacted very similarly. He said, my interest is in my physician client. That is where my ethical interest lies, and I feel very strongly about this, that is who I'm there to protect. He even alluded to the fact that there is a pay differential, a substantial income gap between successful personal injury attorneys and successful med mal defense attorneys. And he said that if someone of his type of knowledge and experience were in it only for the money, they'd be working on the other side. So I think, not that different from the many members of the general public who seem to think physicians are only in it for the money. I would suggest to you that med mal defense attorneys generally are not only in it for the money, and they, on the whole, have the physician defendant's best interests at the front of their mind. So I hope you found this helpful. I hope you found this series helpful on the relationship you can develop with your med mal defense attorney. And I hope that in the event your relationship with your med mal defense attorney is not as productive as you'd hoped, you'll attempt these strategies. Let me know what you think. Let me know if you think of any other strategies or have heard of other strategies that I'm unaware of. I'm always interested to hear from you. If you haven't already, I hope you'll subscribe to the blog and keep your ear to the ground. In about 3 weeks' time, 2 to 3 weeks, I hope to be putting out my first online course on the subject of deposition. Really a turning point moment for many physicians in the course of their medical malpractice litigation, and I think most physician defendants could stand to know a whole lot more about what happens at deposition and how they can best take care of themselves in deposition. All right, that's it for today, and I'll look forward to connecting with you again in a couple of weeks.